Thank you for joining us today for this webinar on the immigration and employment law implications of the EU settlement scheme. I'm delighted to be presenting today with Sanaz Seyfulahi, who is a fabulous barrister specialising in immigration and public law. I've worked with Sanaz before and particularly on providing such training, and I'm delighted she's been willing to join us today to provide you with guidance on the immigration aspects of our withdrawal from the EU. By way of housekeeping before we start, because of the number of people involved and the way that we set up this training, if you have any questions, we'd be delighted to answer them at the end of the presentation. If you could put them in the question and answer box, the chat box, we'll then get to them at the end and we'll both provide support that we can. If you've got anything very specific or detailed, then please get in touch with us by email after the event and we will be able to support you. So Sanaz is going to get the ball rolling today and going through the immigration aspects of this webinar. Over to you, Sanaz.
Thank you very much, Julie. I'm delighted to be co-presenting with Julie today. I'm finding that more and more with Brexit, there's a complete overlap between employment and immigration law, and I'm really delighted to be bringing the two disciplines over together today. So what I'm going to be doing today is speaking about a few areas of law. The first is the EU settlement scheme. I'm going to be speaking about what it is and how it works. I'm then going to move on to the immigration rules post-Brexit and what the main changes are for applicants. And finally, I'm going to be concluding with a very brief section on sponsorship for employers and some things to consider. Slide 2, please. So what is the EU settlement scheme? The EU settlement scheme is the application process for EU nationals and their family members who were in the UK by the 31st of December of last year. There are a few exceptions to this, and it's for people who want to remain here past the 30th of June of this year. The purpose of the EU settlement scheme was to cover the transitional period and to give some certainty for EU nationals and their family members. Some family members may not already be in the UK or have been in the UK by the 31st of December of 2020, but if there was a pre-existing relationship with the EU national, then there is a possibility that those family members will be able to apply to join that EU national by the 30th of June of this year. At the end of the application process, those who have applied will either get settled status, which is also known as indefinite stay, or pre-settled status, which is a 5-year form of leave to remain, and that largely depends on their circumstances and facts. It's very important to highlight that there are EU nationals who have been residing in the United Kingdom for many, many years. Some may have been here for 20 years or more. Some may have permanent residence. They may have a document to prove that they have permanent residence. Unfortunately, those documents will not be relevant after the 30th of June 2021. It's very important that even people who have permanent residence apply before this date. Slide 3, please. Who can apply? Well, the scheme is for EU, EEA and Swiss citizens, the family members of any in these groups. Now, by family member, it's quite a large category. It can include spouse, a partner, parents, and also some extended family members in particular circumstances. As I mentioned slightly earlier, if you're not in the United Kingdom by the relevant date, there is a possibility of joining after if there was a pre-existing relationship with the EU national. There's also scope for former family members, for example, following a separation, in a marriage, death, or following a relationship breakdown. There's also scope for the family member of a British citizen who had lived with that British citizen outside of the United Kingdom in another EEA state before returning here. We also call that the Surinder Singh route. Or the family member of a British citizen who also has EEA, EU or Swiss citizenship, or who lived in the UK before getting that British citizenship. There are also a number of other categories which I've listed and you will see on the slide, including the child of an EU, EEA or Swiss citizen who used to live and work in the UK, or the primary carer of a British, EU or EEA or Swiss citizen. Now, some of these categories, the ones that go over and above spouse or extended family member, will require quite careful consideration in respect of the application to be made, because there are specific rules and guidance that would apply for each of those categories. Slide 4, please. Now, there are some people who will not need to apply under this scheme by the 30th of June of this year. Those who have indefinite leave to enter the UK will not need to apply. Those who have indefinite leave to remain will not need to apply. Now note, that's very different to permanent residents. Irish citizens, including British and Irish dual citizenship, a frontier worker. Now, a frontier worker is someone who lived outside of the UK but worked in the UK by the 31st of December of last year and has worked in the UK once in every 12 months at least from the time that that person had started. Unfortunately, no family members can apply with as dependents under that category. You also wouldn't need to apply if you're exempt from immigration control. And of course, you can't apply if you have British citizenship, and there would be no need. Slide 5, please. The big question, the burning question is, well, what if an applicant is not in the UK by, or wasn't in the UK by the 31st of December of last year? Well, as I said, there are some categories that have to be considered specifically, and there are some possibilities if an applicant was not in the UK at this date, but wasn't out of the UK for more than a 6-month period. So you will really need to get specific advice for any particular case if there is some doubt about the timings. Slide 6, please. Now, how do you apply? That's the burning question. Well, the first thing is the application's free. There is a requirement for proof of identity, such as a passport. Family members will require a digital photograph, which will be taken via a phone. And these can be scanned and uploaded using what's known as the EU Exit ID Document Check app. And you will see on the slide that an Android phone or an iPhone 7 or above can be used, and somebody else's phone can be used if necessary. There is also a possibility of making a paper application, and there are some applicants who will have to make a paper application. Now, that's why it's very important to check the relevant guidance applicable at the date of the application, because the UK VA, who is responsible for processing these applications, will often change the application process. And it's very important to make sure that any applicant is up to date with the requirements. And I know that some extended family members, for example, a cousin who is dependent on an EU national, or for example, an uncle, will need to make a paper application. So it's very, very important not to assume it's all got to be done on this EU app. And as I've said there, some applicants will need to apply via post. And I've listed therein some examples of those applicants. I've already mentioned the primary carer. So you'll see there some of the categories where the Android app / iPhone app cannot be used. Slide 7, please. So what are the requirements and what does it all mean? Well, what's required for settled status is a 5-year continuous residence period. So if an applicant has accumulated 5 years, then that ought to lead to settled status. For pre-settled status, so for those who haven't lived here continuously for 5 years, they will get a 5-year settled, they will get a 5-year pre-settled status authorization at the end of the application process. And the UKVI will make checks via their national insurance number if one is provided. There must be a declaration of any criminal convictions because there are some suitability requirements that have to be met. And if one is applying as a family member, there will need to be proof of the relationship, for example, a marriage certificate or the such. Slide 8, please. So what do you guess in the end? Well, if an application is successful, pre-settled or settled status will be granted. This is confirmed via a letter from the UKVI. Unfortunately, a physical document is often not granted. Status needs to be confirmed online via a link, which makes things very difficult and complicated in some respects for employers and indeed for those individuals improving, if they need to, their right to remain here. But nevertheless, that's the manner in which the status is granted and proven. If an applicant is not successful before the relevant date, before the 30th of June, then a further application can be made free of charge. If an application is made after the 30th of January of 2020, so of course all of those now, then there will be an opportunity to apply to an independent tribunal for a review. And that's essentially an appeal against the refusal of settled or pre-settled status. There's also the possibility of an administrative review, which is a paper review of the refusal, which will require some grounds of challenge. I've put a little note then for employers in terms of sponsorship licenses. So someone who is eligible under EUSS, there's no requirement to have. Slide 9, please. So that was a summary of the EU settlement scheme. And as I said at the start, it's to cover the transitional period leading up to where we are now. So after the 31st of December 2020, there are more points-based categories. We already have point-based rules, but there are a new set of immigration rules that have come into force now. So the way I would ask you to look at this is that these rules are in place now, but there is still a period of about 5 months in which EU nationals and or their family members can make applications under the EU settlement scheme. So at the moment they're sort of coexisting, but after the relevant date, this is the set of rules that you'll be looking at. And what I've sought to do, which you'll see, is put a summary in of what the rules look like now. The rules will apply to all migrants who want to live, work, study in the UK, EU, EEA and all other migrants considered under the same set of rules, the same set of point-based rules. So we'll look at a few of those now so that you have at least a flavour and an overview of what's applicable. Slide 10, please. Skilled workers, the new Tier 2. So some of you may be familiar with the Tier 2. So Tier 2 has gone. The skilled worker has arrived. Some of the requirements under this category are as follows. The migrant has a job offer from an approved sponsor employer. That's not very surprising. The skills levels may be a change and a surprise because the skill level is RQF3. Lots of codes here. This essentially means above A-level skill set. There is an English language requirement and a salary threshold or the going market rate as to the gross pay. Now this list can be located on the UKVI website under Appendix Skilled Occupations. Now the website is quite easy to navigate. There are separate sections on immigration rules, guidance, and that is where you will find all of the up-to-date guidance that you need. And it's quite useful, if possible, to sign up for email alerts on the categories that you would want to keep up to date with. If a salary is lower than the threshold salary, then you may be able to trade in some points in different categories. But of course, each job will have to be considered on its own merits and in accordance with the requirements. And the total number of points needed is 70. So as employers, I would invite you to consider the category that you will be looking at employing migrants in and whether you require the sponsorship license application process in order to enable this to go forward. Slide 11, please. So a few things have gone, and those are the resident market test, the cap on numbers, and the maximum visa time of 6 years. There's also, it's reported, a wider pool of jobs, and you can find those within Appendix Skilled Occupations for some of the occupation codes which may not fall into the skilled worker list. There's quite limited guidance at the moment about how one would match jobs to the occupation code. So what's quite useful, and what I've been informed is quite useful, is the Office for National Statistics occupation coding tool. And we must remember these are very new rules, so they are quite early days. There's also a new rule that says that a skilled worker should be refused if there are reasonable grounds to believe the job has been created mainly to enable the applicant to actually get a visa. So that has to also be carefully considered. And I've also addressed very briefly the health and care visa, because that's part of the skilled visa category, and that would be within the health care system, the NHS, social care, or other organisations offering services to the NHS. Slide 12, please. Then we have the Global Talent Scheme, and I don't want to go into too much detail. You have them on the slides, but it's just to give you an overview of the main changes. So this is open to the EU, EEA and Swiss nationals as well. Enables highly skilled scientists and researchers to come without a job offer. And it's basically for leaders or potential leaders in the field. And the categories are research, academia, arts and culture, digital technology. Now, before a visa application is made, there needs to be an endorsement from the various fields relevant body endorsers, and I've listed those there depending on the area that's applicable. So the first step is apply for an endorsement. The second step is apply for the visa. One needs to be successful under the endorsement category first before moving on to the visa application. It's become a twofold system. For example, if you have an IT leader who wants to come to the United Kingdom from South Africa, I've recently dealt with a case just like that, applied to TechNation, which is for digital technology, for an endorsement for being a leader. And this person was very impressive on paper in respect of his background. And TechNation said no. So we had to challenge that decision by way of an administrative review within 14 days. with very, very lengthy grounds, cut and pasting various things from CVs, past work, experience, and that decision was overturned in the end, but it just shows you there's an additional hurdle for applicants now. And then also you've got the Arts Council for England. Slide 13, please. So with these new skilled workers, the applications generally made, as a lot of them are, online, but it does depend where the applicant is and whether they're extending or switching their visas. Normal processing time, 3 to 8 weeks. I would always add an extra 3 on the top of that. And there's no need for the sponsorship license to be employed in this category. Forgive me, you know that's to do with the global talent. There's also, slide 14, please, intra-company transfer route. And it replaced the Tier 2 intra-company transfer route. And this provision is largely for established workers who are being transferred over from their employer abroad to work at a related business in the UK. So physically in the UK, not remotely in the UK, and for graduate trainees. And the rules are that the applicant needed to have worked for the employer for more than 12 months, unless an applicant's making or exceeding the salary threshold of £73,900. Thank you. We've got intra-company graduate trainee visa there as well, which is all about transfers to the UK as part of the graduate training programme. Need to have a certificate of sponsorship with information about the role being offered and an eligible occupation. Slide 16, please. So finally, I'm going to deal with the last few categories in brief. You have the creative role, which is creative industry roles. There's the sporting route, and that's slide 17, please. International sports people, again, sponsored by employer licensed. And finally, the youth mobility scheme, where it's a 2-year visa for those nationals listed on slide 18. Slide 19, please. I know that Julie's going to deal in more detail with specific employers' concerns or things to look out for, but just to highlight that you will need to sponsor any worker you wish to employ who are not settled or do not otherwise have the correct immigration permission to work in the UK. You need to ensure, slide 20 please, that your business is eligible. You need to ensure that you check specifically what type of application is likely to be made for that applicant and who internally is going to be responsible for the management of the sponsorship license process. Always please check the most up-to-date guidance for assistance. The UKVI also offers sponsors assistance. There are various email addresses as well as the guidance to assist you. And if you have any doubt, please take advice. You currently don't need a sponsorship license to employ someone to work for you remotely from overseas. This has been confirmed categorically. However, that's only from an immigration perspective in terms of the applicant's visa requirements. That in no way means that it's a possibility, a straightforward possibility. There are tax liabilities, you have employer responsibilities, and specialist legal advice must be sought in respect of all of those particular issues, because the immigration status issue in terms of remote working is just the start of it. So that is my summary of the EU settlement scheme and the main changes under the points-based system as of the 1st of January of this year as overview. And I hope you have now got a flavour of what the rules say and what Brexit has impacted upon the rules. And I'm going to hand over to Julie now to talk about the employer's processes. Thank you, Julie.
Thank you, Sanaz. That was really informative. As you pointed out, the crossover between employment and immigration and that overlap is something that we don't ordinarily touch with as an employment lawyer, but with these schemes coming into play and looking at the existing staff and recruitment processes, it's something that we are looking at more. So it's always great to have someone that we can turn to for that specialist advice. So I'm going to look at the implications of Brexit for employment law and particularly just looking at the process you need to follow for EU, EEA or Swiss citizens following our withdrawal from the EU on the 1st January. We're going to look at what you need to do in terms of avoiding employment issues arising from the new immigration rules, and a tiny bit in terms of what we can expect from EU employment laws going forward. And finally, how to deal with the current conundrum of working from home and potentially having staff who have moved back home, albeit in the EU, during this pandemic and the implications of that. So we can move on a slide, Kit, that'd be fab. So I want to look initially just at the right to work and general considerations, because as an employer, you have an obligation to carry out right to work checks on all prospective employees before employment starts, and for some employees throughout their employment. And the reason we do the checks on all employees, because you can't make an assumption on someone's status by their application, and we provide a consistent approach to check identity and to check right to work at the start of the process. I think it's important to set out how important it is to manage your immigration obligations, because there's a civil penalty that can be imposed on employers who employ someone who does not have the right to work in this country, and it can be up to 20,000 for each individual. And there's also the criminal penalty if you employ someone who is illegal or you have a reasonable cause to believe is disqualified or illegal or unable to work in this country, and that can be a fine or imprisonment up to 6 months. So if you conduct your right to work checks, you would have a statutory excuse if for whatever reason an individual hasn't got the right to work or has fraudulently provided you information that you've reasonably been able to rely on. But if we go on to the next slide, Kit, we can look at some of these in more detail. So let's look at, firstly at this EU settlement scheme. So up to the 31st of December, so as of the 1st of January of this year, you would have continued your ordinary recruitment processes. And as of the 1st of January this year, this new scheme is in place whereby the right of freedom of movement of workers has ended, and EU citizens either have to have settled status, or they have to, if they've not been in the UK and not entitled to settled status, have to have the correct visa in place. A transition arrangement has been put in place for the first 6 months of the year up till the 30th of June, whereby up until the 30th of June, a UK employer can rely on your usual right to work checks. So the right to work checks that you've used up to this date in confirming their eligibility to work, and that means for EU or EEA or Swiss citizens, you have a right to look at their passport or their ID card to confirm that they have a right to work. And in fact, up until that date, you cannot request that they have EU settlement scheme, and you can't require them to show you that they do have settlement status, because they don't have to have it in place definitely until the 30th of June 2021. So up until the 30th of June 2021, you should continue with your current process in terms of existing staff or new recruits during that period, in that your right to work check relies on their passport or the ID card that you rely on. Can you move me on one, please, Kit? So now the difficulty we have in this in relation to this process is you can't require your employee or your new recruit to apply for EU settlement status, and you can't require them to show you that they have proof of that status before the 1st of July. However, as an employer in this country, you have a duty to ensure that all your employees are legally entitled to work in this country. So you have that juxtaposition of a situation where you can't require your employee to provide you with evidence that after that date they will have eligibility to work, but equally you still may fall foul of the laws. But what it effectively means is that there is this transition scheme that has been set up, and the guidance suggests that there'll be no civil penalties on employers in terms of existing staff up till the 31st, so the 30th of June and thereafter. And also we cover it in the next slide onwards, but the guidance currently states that you do not have to undertake retrospective checks on existing staff. So as of the 1st of July, when the new scheme goes forward, and for any existing staff, the guidance says currently that you don't have to undertake retrospective checks. But that leaves you in a situation where you're not sure whether someone has a settled scheme and they're continuing to be employed by you. So looking at your duties as an employer, if you have someone who is not legally entitled to work in the country, then it is a criminal and a civil offence to employ them, to continue employing them, and therefore you can dismiss them, but you have to follow a fair process in doing so. So the first step is to conduct the correct right to work checks, and if you do conduct the correct right to work checks, you would have a defence against any prosecution and a civil excuse against any civil penalty. The clearly up to date for any immigration issues, you will have used you would have asked for the original documents to show that your employees who required a visa have the correct visa in place, and you would use the checking process for the UK Border Agency. But anyone having gone through that process and asked the UK Border Agency for entitlement to work may have come across the conundrum where the response is that the UK Border Agency cannot confirm whether that person has the right to work after a certain date, and you're left in the position where your staff member is telling you that they have applied for their visa going forward, and the UK Border Agency isn't confirming or denying that that is the case. It's really difficult situation to be in as an employer. You have to balance your responsibilities as an employer and the employment rights that someone may have, but also the importance of immigration, the immigration obligations. It's clear in that respect that immigration should always outweigh, but it's all about a fair process. If you can move on to the next slide, please, Kit. So in terms of the key issues that people look at in terms of immigration and the crossover with employment is whether you have a right to employ someone, and if you do not, then how you fairly dismiss that person, and also the issue in terms of avoiding discrimination. Now, one of the key, obviously the Equality Act sets out certain conduct which is prohibited that could constitute discrimination, harassment or victimisation in employment. And there is a specific code for public sector authorities to ensure that you act in accordance with the public sector equality duty. And the Home Office guidance is that you cannot discriminate against someone of EU, EEA or Swiss citizenship. And you cannot require them, as I say, to show you their status under the EU settlement scheme until after the 30th of June. So you cannot make an offer of employment now or continued employment in which you say this offer is conditional on you having EU settlement scheme settled status after the 1st of July. And you cannot specifically target your EU national employees or recruits in checking their right to work, as that may constitute harassment. And you've got to avoid any policies which indirectly or disproportionately disadvantage a section of the community. So if you can move on to the next slide. So as I said, there's the discrimination angle and then there's the unfair dismissal. So if you have an employee who has over 2 years service, you may be able to dismiss someone immediately if you know that they do not have the right to work in the UK, and that's under the illegality reason. But you only use that if you absolutely know, so you have proof that they don't have the right to work in the UK. If you believe on the basis of the information that you've got that they don't have the right to work in the UK, but you don't have absolute evidence of it, then the best course of action is to consider any potential dismissal as some other substantial reason. And that is about you showing that you have undertaken a sufficient investigation and you have sufficient evidence to reasonably believe that they do not have the right to work. And it is about that procedural fairness. It is about undertaking the checks and communicating with the employee. Can we move on to the next slide, please, Kit? So looking at just specifically, let's look at the impact for EU employees. So for new joiners, as in all new joiners, before employment, you should undertake right to work checks for every new employee. Before the 1st of July 2020, that check will be as you have been doing, using EU passports and ID documents. And you cannot make it, as I say, you cannot make their employment conditional on them having or applying for EU settled status. For existing staff, as I say, the current guidance says you don't have to do retrospective checks, but this doesn't help you understand whether they've got they're legally entitled to work or they do have settled status, and we don't know whether or when that guidance may change, and therefore it's all about ensuring that you are prepared and you understand where the risks are. So, as I say, employment law is important, but the penalties for immigration law outweigh the risks of an employment tribunal claim. So we have to bear that in mind going forward. Can I have the next slide, please, Kit? What we would say is, while you can't require your existing staff to provide you with their settled status or to tell you that they've applied for it or any progress with it, what you can do is undertake a review of your existing staff to determine whether this is something that you have to consider further. What we would suggest, first of all, is regular and open communication with all staff, including your EEA staff, and that is setting out that after the 1st of January, the rules in terms of employing EU staff have changed, and setting out where people can find the information, so signposting them to further advice and information. This is a generic letter to everybody. Then you can ask any employee when they arrived in the UK before the 1st of December, to check that they are eligible for it. When you're approaching June, so you can then look at adopting a more targeted approach in May or June, and you can provide specific communication to anybody who has not already given you positive confirmation of status. And by this, we're talking about still supportive measures to ensure that people are aware of what they need to do to obtain settled status, and what if there's anything that you can provide them, any support that you can provide them to support their applications. It's important that when you're targeting this measure, that you do so because you're aware that they have an EU passport, not because of any assumptions regarding their status. It's what we would also say very carefully at this stage is, when you're providing information and support, please don't provide immigration advice unless you're qualified to do so. So signpost to other places, provide information, provide support, but be careful about going from that fine line between immigration and advice. As of the 1st of July, you can undertake an online check of all your staff, and as of that date, if there's any of your existing staff who you are aware of are on an EU passport that do not have settled status, then you can write to them to say that, you know, the online check indicates that they don't have settled status. Have they thought about it and what stage they're at? As we say, you don't have to undertake retrospective checks, but being prepared and understanding the situation you're in, it does not is always a good way to run such matters. If for whatever reason, and we've gone down to fair dismissal, but as I say, you don't have to retrospectively check, but we've put this in just in case the guidance does change. If you get a negative verification as of the 1st of July, as I say, it doesn't mean you can automatically dismiss an employee. You follow a fair process. The fact you don't have to do retrospective checks doesn't mean to say that you could choose to do them, and you could go through a process if you are not satisfied that someone has the right to continue working in the country. For anybody who you find out does not have the right to work in the country, then you need to consider whether or not you want to continue employing them, and if so, dismiss them with notice or give them payment in lieu of notice. We'd say that any company policies are aligned to the changes in terms of the right to work checks, so all your recruitment policies are up to date in terms of what you're going to expect of people as of the 1st of July. Could we move on to the next slide, Kit? Very quickly, there's been a lot of talk of what we can expect from UK law now we've withdrawn from the EU, and what whether or not judgments are going to continue to be binding on the UK. Under the withdrawal agreement, any substantial changes to employment law which diverge from EU law must be subject to appropriate rebalancing measures. It's likely, therefore, that any changes are not going to be so significant as to need to go down that route. Certainly not in the foreseeable future, while we're still getting used to the new process. It's likely that courts will continue to have regard to the EU tribunal decisions, court decisions, and it's likely that even if they're ongoing, they're not binding, they are going to be something that UK courts continue to look at to ensure consistency of practice, as in the same way they do for other tribunals. Could we move on for the next slide, please, Kit? We don't expect it to be a bonfire of worker rights. There have been a number of talks in terms of working time regulations and TUPE. I'm sure anyone who deals with TUPE would like it to be ripped up and started again. And holiday rules have created some situations which haven't necessarily been conducive to good business, well, commercial business practices and agency workers. So these are the areas that we would look at keeping an eye on to see if there are any changes. But at the current stage, any changes are going to likely to be minor to avoid this rebalancing exercise. Could you move me on to the next slide, Kit? Finally, just wanted to touch on this because Sanaz raised it in terms of having staff who are working overseas but for you, and I've had a number of queries from clients who have staff during lockdown who've decided to move home rather than continue to pay for housing in the UK and have wanted to work remotely from their home. There are a number of issues that you need to be aware of. Now, I couldn't begin to start talking about the tax implications of this because tax, I'm afraid, goes right over my head, but there are significant tax implications of somebody working overseas but being employed in the EU. The worst being that they could have to pay tax at source, i.e. UK tax, but also tax in their home country, or they could be considered a branch of your business, and therefore you have to register PAYE, etc. in their home country. There are the immigration requirements, the data protection issues and transferring of data. There are employment law issues as well. So there are a number of factors that you need to consider, and we'd suggest you take advice if this is something that is affecting you. I think that is the end of our slides. Thank you very much for listening. I'm just going to see if we've got any questions now. Bear with me one moment. Oh, right, we have. Marvellous. So I'm going to read them out and I'm probably going to pass them all over to Sanaz. So let's see how we go. How would you proceed with a couple who did not get to marry in the UK by the 31st of December due to lockdown? I working on the basis that for this question that that one of the parties in the couple requires a visa of some description. It's likely, I mean, I'll pass it on to Sanaz, but it's likely if they're already in the UK by the 31st of December, then they can apply for a status. But can you cover that one, Sanaz?
Definitely, yes. I would agree. I would concur, Julie. So in terms of the dependent categories or family members, it's not only a spouse, it's also a partner. So in respect of a partner, there are two forked issues to consider. The first is whether the couple have lived together for a period of 2 years, which is the standard mark that the UKVI will use. And in the alternative, if they haven't and they have a child, that's also a relevant consideration. And if neither of those factors apply, then there may be other evidence that can substantiate the application. So I wouldn't automatically dismiss the application solely on the basis that the couple couldn't marry due to lockdown. But it appears to me that if one of them were a EU national and the other is a dependent or a partner of that EU national in the UK, but couldn't marry, they still hold the status of partner. So definitely some consideration will need to be given to the partner route in terms of unmarried stroke durable partner category.
And we have another one which is for you also, Sanaz, which is, can an EU national who's been in the UK from August to October 2020 now apply for pre-settled status from outside of the UK?
So I think yes, because as long as the person stroke people were in the UK before the 31st of December for at least a day, but not away for 6-month period, there is a possibility. So the specific guidance will have to be considered that there are definitely allowances for people who had resided here for a period, but then left. So that has to be considered. There will be various considerations in terms of how long they were here for, the absences, what they'd established, but it's not automatically dismissed just because they weren't here.
Thank you. And how do EU nationals bring their family members in after June 2021?
So that will be under the new points-based rules, and it will have to be under one of the categories, either one of the ones that I've covered as a dependent, or on the alternative categories that are available, depending on what is applicable to those particular situations.
Thank you. Let's see. Can the 5 years continuous residence in the UK be in another immigration category? For example, leave on a tier 4 visa count towards the 5 years?
Well, ordinarily, those individuals who would be applying under the EU settlement scheme wouldn't have required a tier 4 permission. So the scheme itself probably wouldn't be applicable to that individual. But if for any reason it is relevant or applicable, then I know that under the EU settlement scheme, what they're looking at is residence. So it's about how long the person has been residing here. So if the person has been here for a period, then it will of course count, and the checks are undertaken, it will of course count to the final assessment.
How do we deal with delays? And I know this has been an issue for a number of people. So over a year for consideration and still no response and no time frame from the Home Office. If this is a question in terms of from an employer, then as I say, your responsibility at the moment as an employer is to support an individual going through that process. You've no responsibility to do retrospective checks if you don't get that response by the 30th of June, and even if you did choose to do the checks, you could, in communicating with a member of staff about their process and what they've done, you could take a measured approach as to whether you think that it's likely to get pre-settled status in any event. But I'm going to pass it over to Sanaz, see if you've got any further.
So in terms of the lawfulness of the stay, there's a pending application. So that's something that's obviously of consideration, because just because they haven't had their decision yet doesn't automatically bar them from being here. Their application is pending. Delays are a huge problem, particularly for more complex applications, mostly paper-based applications. There are a number of things that can be done. The first thing is obviously chasing letters, which show that you have made attempts to move things on, and it's something that you could rely upon if you take the last recourse, which I'm coming on to in a moment. The second is to try to involve an MP. I know some people try to do that. The final route is a challenge by way of judicial review. Now, obviously, that's the final route, because nobody wants to undertake complex proceedings, expensive proceedings. But before judicial review proceedings are lodged, what needs to happen is there needs to be a pre-action protocol letter. And within that pre-action protocol letter, the issues are highlighted. And delay will obviously be an unreasonable challenge, a challenge on the reasonableness or unreasonableness of the decision-making process, because it hasn't taken place. And sometimes what we find in those cases is that if a letter is drafted and sent, it tends to move things on a little bit. But obviously judicial review is the final step because it's self-explanatory.
Can a child dependent who has pre-settled status be able to apply for settled status if the sponsor parent does not meet the eligibility requirements for settled status at the end of the 5 years due to frequent and long absences from the UK?
So this is an interesting one. My feeling on top is yes, because the UKVI is dealing with child applicants separately, so there's no need for a child applicant to wait for the parent's decision before making their own. And obviously, if the child meets the requirements, then a separate application can be made for that child. So it's not necessarily that parent's application is going to doom the child's application, if that makes sense.
Does. One question, yes, we can send out a copy of the slides and we'll do that to everyone that registered for the talk. So let's see, we have a couple of EU staff who've worked with us for a number of years. They tell us they have settled status, but do I need to ask for evidence of this, and how can it be obtained? So first of all, before the 30th of June, you cannot require them to provide you evidence of it. You can ask them, but you cannot require them. And if they have advised you that they do have settled status at the time, for the time being, I would take them at their word. As of the 1st of July, you will be able to check their status on the following the online check-in system. As Sana has pointed out, that people aren't getting paper evidence of their settled status, which is incredibly difficult for people to manage. If you're used to a passport or an ID or some sort of verification that you can provide to people, and instead you have to rely on this online process. But it's relatively straightforward, so I would suggest that after the 1st of July that you go through the process to just check that. If there are any queries, if they don't have it, then all I would do is drop them a line to say, you know, we've gone through the check-in process. The check-in process suggests that you don't have settled status. Do you want to talk to us further about this? What measures have you had? Do you need any support? That sort of thing. Now, this is a really good question. If dismissing an employee, well, it's a really good question because it's employment. If dismissing an employee on the grounds of statutory illegality because they no longer have the right to work, are they entitled to notice pay? If they don't have the right to work, then surely it be illegal to pay them past the effective date of termination, other than in relation to wages to that point and for any accrued but untaken holiday. This is the difficult crossover where immigration and employment law hits, in that you have an employee who has contractual and statutory rights to notice and contractual and statutory rights to pay and accrued holiday pay at the date of termination. If they are illegal, then effectively that contract is frustrated. It should never have happened in the first place, so they don't have the rights. The difficulty you have is you can only dismiss someone on the grounds of illegality if you know that they are illegal. So if you have evidence, you can absolutely prove that they are illegal and they shouldn't be working in the country. If you believe they're illegal based on going through a UK border agency check, or because they can't provide the documents for you at the time you ask them, then your best bet is to dismiss them for some other substantial reason, which is basically we cannot prove, we believe that you don't have the right to work. You follow the fair process, and what we would suggest at this stage is that if you do dismiss, you do not allow them to work their notice because they're continuing to work, and you make a decision of whether or not you're going to pay them in lieu of notice on the basis that you believe they don't have the right to work, but you can't prove it. So you could make a decision that you're not going to pay it, and if they challenged it, then you could say, well, once you can show me you had a right to work, then we will reimburse you that amount of money. So you can do it that way. In terms of holiday, accrued but untaken holiday, it's very similar in that they have accrued it under their contract up until the time that you believe that they didn't have the right to work. So anything that they accrued before the date that you have a concern on, they are entitled to. After that date, you take a decision. And you need to be able to justify the decision. So if you're going to pay it, you justify it on the basis that you believe that they don't have the right to work because you don't have sufficient evidence, but they have. So you pay it on that basis, or you say to them, we are dismissing you because we don't believe you have the right to work, and as such you're not entitled to these points. But if you can provide us with evidence that you do have the right to work, we will consider reinstating you and we'll reimburse you for the notice pay and or accrued untaken holiday, and do it that way. How can a family based in the UK hire and sponsor a nanny, considering that only a UK organisation business is eligible to apply for a sponsor licence?
There is provision within the immigration rules to hire help. It's actually called a domestic workers visa. So there is the potential for applying for that type of category of visa for a nanny, as long as the eligibility requirements are met. And one of them is that you have to have had to work for your employer for at least a year prior to the application. But that is the category that you will be looking at. So it's not specifically linked in with the new rules, but it does exist.
And would an art person or a model qualify for pre-settled status if she was coming to the UK in 2019, 2020 for a couple of days due to work purposes, but they don't have UK proof of address apart from a travel ticket? Can they apply from outside the UK?
Oh, that one I'd have to look into a bit more detail. So if Julie, I know Julie, your email address is available at the end. So if the person wants to email you and then forward on the email to me, I can look into it a bit more specifically, because it depends largely on how many days. I know you said only a couple of days. It's mostly about people who are resident here, but there may be some way of gearing that towards that particular issue. But I'd like to look into it if possible. So I'm more than happy to assist in a general way, and Julie's address is available on the screen, so please do drop me an email.
It seems from the question, if they're only here for a couple of days here and there, then it's unlikely that they could show residence and therefore apply for it. But by all means, do email if you want us to look into that. Another question: what is a non-EU child? I'm not sure I understand the. Do you understand?
I think that's linked in with the first question about the child. I think.
Oh, non-EU. Oh, yeah.
It might be. It might be. So there are different schemes and provisions available. If it's not under the EU settlement scheme, then there is the potential for a human rights application for a child. But again, it will need to be considered alongside the particular factual matrix applicable to that scenario. So just to re-clarify, under the EU settlement scheme, a dependent child can apply in his or her own right and as a separate application. And there is also a provision under the immigration rules that there are human rights applications that can be made for some particular circumstances. So that's a different type of application, but we call that a human rights application because it's the right to family life and largely would be an Article 8 application.
Thank you. Right, this one's for me. Can an employer be fined for hiring an EE national before the 30th of June who he thought would qualify for pre-settled status but is not clear? It's a really good question. So first of all, the guidance suggests that they're not that you won't be subject to a civil penalty for employing EU nationals during this period of time. So that's the first point of call. Secondly, that the transition arrangement up to the 30th of June means that you cannot require someone to show that they have settled status, and you can hire someone on the basis that they have an EU passport up until that date. So you can't be fined for hiring somebody. As of the 1st of July, if that individual does not have settled status, then you can go through the process of discussing that with them and determining what action, if any, you want to take. But the current guidance says there's no retrospective requirement. So technically, if you follow the guidance, you don't have to do anything. Once you've hired them before the 30th of June, then you're entitled to rely on the ID that they provided you at that time. But you're not going to be fined. It doesn't really matter whether you think they can qualify for pre-settled status, because that's their responsibility, not yours at that stage. It's just about providing support and guidance for staff to ensure that they understand what they will need to do. One of the reasons that government have gone down the route of not requiring employers to prove it is because their view is that once living in the UK, you need this pre-settled status or settled status in order to do so many different things, from applying for loans or buying houses or renting property, that they believe that it creates such a hostile work environment that anybody that is entitled to it would apply for it and would do so straight away, just so they know they have it, and therefore you don't need to do anything about it. I mean, that isn't that helpful, because there's a lot of people that probably don't think like that, but that's the current guidance and how they're operating. I'm very pleased to get to the end of the questions. Thank you so much for participating and joining us. My email is there. We will send you the slides. If you've got any other questions, please feel free to contact us. If there's anything that came up as part of this process that you think you'd like more training on, so one of the things that I was thinking about was potentially looking at recruitment as of the 1st of July and how you recruit and what you need to do going forward. So I think that would be something to look into. But do let us know if there's anything that we can look at in terms of additional training going forward. And we're always ready to listen and think about putting something forward. Thank you very much. That's bye from all of us, and enjoy the rest of your day.